Representative Mackenzie, for your 5 minutes of questioning.
Thank you, Mr. Chairman, and I appreciate the topic of today's hearing. Very important that we do focus on the benefits that American workers have earned and they deserve, and making sure that fees aren't excessive, that lawsuits aren't frivolous, and that ultimately that money makes its way back to those American workers so that they can enjoy their retirement. Just a couple quick questions that I have for the panelists. The first is for Mr. Butash. I understand from your bio that you've practiced ERISA law for almost 40 years. Have you seen this being a trend of frivolous class action lawsuits over your career and during the last decade? Is that a trend line that you're seeing an increase of these?
I think there has been. Trying to think back to earlier in my career, the types of ERISA litigation cases that I saw and read about, and they seemed, there were different focuses at different times, but there didn't seem to be this deluge of cases. And again, I comment that they seem to be largely brought by, a handful of the same law firms, and so they're recycling the same pleading against deep-pocketed defendants or large plans in the views of getting a quick settlement. If I may, Ranking Member DeSaulnier mentioned the number of investigators at the DOL compared to the number of benefit plans, and it's important to remember litigation is not an investigation tool. You're supposed to have a claim before you file your complaint. And I think one of the key problems with the pleading standard in general, and with the Cornell decision in particular, is that what the Supreme Court said in that case is when a plan is engaging a service provider, which all benefit plans do, I think it's almost, it would be imprudent not to engage professional record keeper, professional asset manager. What the Supreme Court said is that if you want to allege that's a prohibited transaction, all you have to allege is that the fiduciary hired a service provider to provide services to the plan, and instead the burden then shifts to the defendant to prove that it meets the exemption for reasonable contracts or arrangements with service providers. So I appreciate that that was a 9-0 decision, and I'm not quarreling with the legal analysis of that decision, but the result is I don't know what adjective to describe, but and it would not be novel for Congress to step in after a Supreme Court decision and to return expectations to where they were. There was a case back in the early 90s called Harris Trust that unsettled all expectations in the particular issue that was at issue in Harris Trust. And a few years later, Congress passed legislation to address the Harris Trust decision. So we really commend Representative Fine's bill for addressing the Cornell decision in a way that we think is very responsible and really doesn't detract from aggrieved participants to bring a claim where there's genuine harm that they are aware of.
And time is running down, so I'll go to Ms. Dudley here. Regarding President Trump's executive order on August 7th about litigation risks that impede American workers' retirement accounts from achieving competitive returns and the assets diversification necessary to secure a dignified retirement, what are examples that you see of threats from these lawsuits that are being brought by a small number of law firms, as was just stated, against these defendants? What do you see that the result is on stifling innovation or making changes for employee benefit plans that actually don't benefit the employees?
Absolutely, great question. Again, we conducted an informal survey. Risk of litigation is a key, a significant factor in their decision to offer new services or benefits. Almost 89% said that of defined contribution plan sponsors. Almost 29% of our plan sponsors that answered the survey say they won't offer something new unless other people are doing it. Almost 25% say they will not offer, have decided not to offer more assistance because of the risk of litigation, and almost 43% say they will not provide lifetime income because of the risk of litigation. I mean, it's very serious.
Those are serious findings. I appreciate you bringing them to us. Obviously, again, we want to make sure that there is the appropriate amount of flexibility and innovation in the market for these employee benefit plans because, again, as the markets change, we need to adapt to make sure that workers have the benefits in their retirement that they not only deserve, but they've earned over the years. So I want to thank all of you again, and I yield back to the chair.